didn't answer my question. I need to know how I'm going to proceed, because we can have the trial if you just sit there. I'll just tell the jury you've decided to represent yourself and you might not say anything today. And now I'm not going to let her walk all over you and try to trick you because you don't know some of those rules and statutes. But I am absolutely going to require you to know what you're doing because you've chosen to do it. That doesn't show bias. That shows impartiality.
There's no partiality. I have the.
Once again, Mr. Crusoe, that's your opinion. No, it's your interpretation of the facts. So you have to appeal.
This is an important legal distinction. Impartiality doesn't mean the judge lowers the rules. It means the same rules apply to everyone, even if one side doesn't know them.
And look, dude, the fact that you're not in a jail cell right now shows how impartial I am.
When Officer Price literally pulled up to me my 11 days before any of this even happened and talked to us about the drunk and traveling. Even told me I was well within my rights. Gave me every clarification that I was well within my lawful rights. This was all a retaliatory thing from the beginning. And then even when the chief called me. He even called me trying to overrate. I was like, what's that overrate? And then he goes to some more people. And then he tries to get me to not pursue legal matters. And then he's mad at me. And then the day that I file for my body cam, I'm getting removed from here on a Little League.
And stop. Hold on. I don't doubt that it is. But I think we got into this a little bit the first time you were here, and I told you that's not proper for this venue. If you want to complain about the way the Huron Township Police Department handled this, you can file a civil lawsuit against them if you want to. But what's in front of me is one civil infraction and 2 misdemeanors. That's what's in front of me.
Notice the tension rising here. The judge is signaling something subtle but serious: restraint. In court, patience from the bench is often the last warning before consequences.
Every time I force it to make my case, the court just keeps setting all my stuff and not allowing me to do it.
Because I'm going to make decisions based on the facts. That jury hopefully is going to make decisions based on the facts that are presented.
How would it be facts if this court continues to not allow me to get my facts?
Because the facts you want to get into, what facts do you want to get into? The chief had some conversation with you?
It's not even just that. I mean, well, yeah, regardless, I have all of that to cover too. The fact that my offense, based off what I was doing, I didn't have to produce any of that. It just keeps all just thrown aside. Every single and just not even trying to acknowledge any of it.
So hold on. I don't understand. Hold on. You want to be able to testify to this jury?
No, it's not. I'm just finding. That's what I'm saying. It's the amount of judicial bias in this case.
I'm done hearing about bias. You need to appeal me. I don't feel I have bias.
Well, I don't feel that I don't have a fair trial here with everything that's continuous why to file policy. Why did we?
And I've denied all these things.
Well, of course you can deny it. Again, show them again. Then this.
Once again, Mr. Crusoe, just because I disagree with you doesn't mean I'm biased against you. Maybe I just think you're wrong. Is it possible we could have a difference of opinion?
This is where many defendants get lost. Complaints about police conduct don't belong in a criminal trial. They belong in a separate civil lawsuit. Wrong venue, wrong moment.
Told me that she was just down in housing myself because the Secretary of State will make sure that this isn't a big deal. I'm
not going to.
It's so impartial.
I've never brought a Secretary of State, have I?
This is where this all stems from. These are the things I've been trying to get noticed. This thing talked about.
What do you want getting noticed that we're not getting noticed? It is not collusion. What? All right, listen. What are you going to do today? Because I'm ready to bring the jury, and I've denied all. Stop. I've denied all your motions. I'm ready to set the trial. Are you not going to be here?
Nothing you can see in 48 years, right? And it's especially regarding the jurisdiction stuff.
Once again, we're at $300 now. We're going to $400. I'm going to ask you the question again. I'm ready to call the jury. Are you going to leave?
There's no way they're going to hear a trial here.
That didn't answer my question. I need to know how I'm going to proceed because we can have the trial if you just sit there. I'll just tell the jury you've decided to represent yourself and you might not say anything today. So that's the way you want to go with the trial.
I do. It's against that.
Okay.
Everything is.
Okay. Okay. No, let's on the record as you feel they should be.
I brought the sites that I left the sites at home and bring up the person's jurisdiction.
And hold on. Once again, I want to just, because he just walked in the room. Once again, I want to let you know there's a very competent, experienced legal attorney here, defense attorney here, that's more than willing to help you with this if you want his help.
Well, this organization who is supposed to be.
And that ain't going to happen.
Well, anybody showed you were supposed to release yourself. It's in the book.
And I don't think I've shown bias. That's what we keep. Once again, you and I disagree. That's okay. That's America. You have to appeal me. You don't just keep to argue. You don't get to argue the same thing over and over and over until I agree with you. That's not going to happen. I know I am not biased towards you. I also know that your ideas of how the law applies in mine are vastly different. But because I'm in the black robe and I'm in charge of this trial today, my ruling stands until a circuit court judge or some higher court tells me I'm wrong.
This is the fork in the road. Participate or stay silent and let the trial happen without you. Either choice carries serious consequences.
That's just the reality of it.
That's what I have to do. You're creating this course not going to rule it the way it's supposed to. You're not going to stand by your
Not by your definition, I'm not.
The Secretary of State, Attorney General, and you have never heard anything. I don't even know if you're lawfully allowed to concede it. You can say that again. It's been proven on the record.
No, it doesn't need to be proven on the record. Show me a statute or a court rule in Michigan that says I got to prove that. Statute, Michigan statute, or Michigan court rule says I got to do that.
I have it in there. My father's in Slogan.
So you're such a great legal scholar.
MCL 168.420 and MCL 168.467 mandates that the judge must file an oath with the state, and you provided 1X. That is what you have to ensure.
Okay. Then I don't have it. You can file that motion to dismiss with the circuit court. But we're having a trial today.
We're going to have a violating participating trial that's going to be impartial against them, right? It's going to be completed. There is no impartiality for this supposed to be here. It cannot be a fair trial for all of the amounts of evidence in there.
Okay. Anything else you want to put on the record before I call the jury in?
Yeah, lengthy statement I was all put on the record before we get.
How lengthy?
It's
Go ahead. Just so you know, you're putting this on the record. You're putting this on the record. I'm not listening. She'll get the record.
Your Honor, Judge Oak, I respectfully assert that this court has failed to by files of the case. Yeah, well, then she can make it. I respectfully assert.
Here's the hard truth. In the courtroom, a judge's ruling stands unless a higher court overturns it. Arguing longer doesn't change the ruling. Filing an appeal does. This moment captures the reality of court power. The law isn't debated endlessly, it's enforced. And whether you agree or not, the process keeps moving forward.
On the pending motions, including the jurisdictional challenge, they've immediately dismissed this case by citing overwhelming evidence of judicial misconduct, bias, and due process violations. So these issues remain ignored. I will see immediate appellate relief, hold all parties accountable, including Your Honor, Judge Martin, Judge Tina Green, Prosecutor Caitlin Margaret Foley, Officer Miro, Officer Sisai, Officer Smith, Chief Everett Robbins, and the Huron Township Police Department. I further assert that if this court continues to proceed with the presumption that I engage in commerce, it must present evidence to substantiate his claim. Without such evidence, this court has no authority to enforce commercial motor vehicle codes or ORD ordinance, and any further actions would be unconstitutional and unlawful.
All right, here to court this report back in session.
Bring the jurors in. Mr. Crucell, just so you understand the process, we're going to do voir dire. Did you have a chance to talk about the iPad?
No.
Hold on a minute, Joe.
Yeah, I told him I would go over it.
Okay. I understand that's your position, but I'm still going to explain things as they go. All right. I mean, I just want you to understand what's going on. So if you decide you want to jump in, you'll know where you're at. Understood? I'm not trying to talk you into participating. I'm just letting you know what's happening. I'm going to explain things as we go for you and them. You got that?
I suppose I don't understand why I need to sit here and use my time for an
Because if you leave, I'm going to ask you a bench warrant, and you're still going to have to deal with this down the road. At least this way, listen. Here, one of two things can happen today if we have the trial. Either they find you not guilty and you're done. Then you can file all your grievances and stuff. Or they find you guilty and you're just filing one more appeal.
Instead of wasting everyone's time.
You've already wasted their time because they're all here. They're all here.
Well, that's why I filed these things weeks ago. These things should have been addressed before this process even took place.
There's a scheduling issue that takes place too.
So
But hold on. Hold on. Don't interrupt. You didn't appeal the last round of decisions. You didn't appeal the decision you didn't like from Judge Martin. You didn't appeal the decision you didn't like from Judge Green. And you didn't appeal the decision you didn't like from me last time you were here. So here's my problem. I'm not going to adjourn today because you say you're going to appeal, because if you don't, we've accomplished nothing and we're no further to resolving these files.
And they had to file a link with the appeals court. I've been in contact with the appeals court.
Okay. Hold on. Let me try to educate you. Okay. You contacting the appellate court, first of all, this should go to the circuit court. All right. You've gone. Okay. So I didn't choose for you to be here, but you're here. Okay. So we have to get through it. All right. So the way it works is you don't just talk to them about an appeal. You actually file and perfect an appeal, but you didn't perfect the appeal. So there is no appeal. You started the process, but there is no appeal. So we're going to go forward today. The only question is, are you going to be in the chair or not?
No, again, if you were to prevent it, we're allowed to stay bond one, correct?
Depending on what I set the bench warrant at. It can be whatever I want it to be. Once again, but see, you think that's bias, right? And that's me explaining to you the way the process works. I could set a $10,000 cash bail on this. And until a circuit court judge tells me that's got to be set aside, it's the bail. That's the bond I set if I set it. Because here's the thing. I'm trying to listen, dude, I'm trying to get you to see I've got a job to do. It's got nothing to do with you personally. All right, you keep bringing this, I'm having so much trouble getting through to you. I'm thinking the next step is a competency exam.
So that fact that she told me that on the record in front of me, and in all the things that she's saying, the judge said, she never said that on the record. I have records.
The judge makes it clear disagreement is not bias. He repeatedly denies the defendant's motions, warns about contempt, and explains that choosing self-representation means following court rules. The judge insists the trial will move forward, telling the defendant his only remedy is appeal, not argument.